0279 Rancho Mirage versus El Gamon. You said we'll have 20 minutes to present your argument upon it. You may reserve any portion of that you want for a rebuttal, but you'll have to keep track of your own time with a clock at the podium for that purpose. We're recording this argument, so in a couple of days you'll be able to watch yourselves on YouTube. Because we're recording that, please identify your client and yourself when you begin your argument. We've conferenced the case, we've looked at the record, and we've read and considered the briefs, so we're familiar with the facts in the argument. So when you come up to speak, just launch right into what you want to discuss with us. Counsel, you may begin.
Thank you. May it please the court, my name is Christopher Graham. I represent Ashraf El Gamo in this matter, who's the appellant in this appeal and the defendant in the underlying matter. I don't intend to take long today, but I would like to reserve 5 minutes in rebuttal. This appeal involves issues of statutory construction on what collection methods are available to a homeowners association in a planned community. Specifically, we're looking at the interplay and construction of ARS 33-1807, which is specific to homeowners associations in a planned community, in addition to providing a statutory lien, also gives limitations on collections by that association, specifically against the real property at issue.
Counsel, your client has paid the assessments, correct?
He did pay the assessments up at the time of the judgment, and the judgment does not include any amount for assessments.
So, how does it, once the assessments are paid, how does the statute operate? 33-1807.
How does it operate?
Yeah.
I think the last two sentences of that statute, or Section A of that statute, are key. It states that the association has a lien for fees, charges, late charges other than charges for late payment of assessment, monetary penalties, or interest charged pursuant to Section 33-1803 after the entry of a judgment in a civil suit for those fees, charges, late charges, monetary penalties, or interest from a court of competent jurisdiction, and the recording of that judgment in the office of the county recorder. That is essentially what we have here. There were no assessments in the judgment, and they received a civil judgment for these other amounts, and I think it bears noting that as far as attorney's fees and collection fees, the judgment doesn't break it down between the monetary penalties and anything they were recovering based on the assessment.
Yeah, but that doesn't really matter as long as they're not assessments, correct? The fact that they're not broken down.
Yeah, well, I mean, it does say in the second session, the association's lien for monies other than for assessments, for charges for late payments of those assessments, for reasonable collection fees and costs incurred with respect to those assessments, may not be foreclosed and is effective only on conveyance of any interest in real property.
And that seems to be the critical language, may not be foreclosed. I suppose you could read that to mean may not be foreclosed under the statute, which I assume is a alternate reading, but that's not your reading of it, correct?
Well, I think the prohibition of foreclosure on anything other than the assessments or those charges related to assessment, when you read it, it talks about the association may get a civil judgment, and in other words, what they're terming a judgment lien on those amounts, but may not, and it uses the word foreclose on that judgment until there's a conveyance of the property. So the way the statute uses that term foreclose talks about a judgment lien and selling the property, the for sale of that property under that civil judgment that the statute.
Well, if you go about halfway down or halfway up, whenever you choose to do it, you got fees, charges, late charges, all the appropriate elements are not enforceable as assessments under the section. So
Correct.
when you consider that it's got under the section, does that inform what may not be uh, uh, the scope of may not be foreclosed means?
I mean, I see that, but reading further down, when it talks about obtaining a civil judgment and has a lien based on getting that civil judgment and recording of that judgment, I think that expands the scope of the statute beyond just the assessments. And that the limitations in 33-1807 go to the civil judgments for money owed to the association other than just for assessments when you read the whole thing as a whole.
So, counsel, two questions. First, do you have any case law or common law authority to that effect?
I believe this is a first impression before this court regarding the interpretation of the statute.
And secondly, is this, you practice in this area?
I do. I started out with homeowners association and done civil litigation.
So have you seen in your practice something to this effect, where a homeowner association moves forward to foreclose on the fee or penalty portion of an otherwise paid assessment under this statute?
I have not seen that. It's typical with this case. The association moved for both breach of contract and foreclosure. I see that commonly
But you thought
throughout.
when the first count was dismissed as moot, that likewise dismissed the possibility of a foreclosure under that statute?
Yeah, that's our position based on the reading of the statute and what it says you can and cannot do as far as foreclosure. And as I mentioned, using foreclosure in the statute, it does seem to incorporate civil judgments based on the language regarding things other than assessments.
Yeah, well, it's not, I wouldn't say it's a model of clarity, but you can fight through it.
Okay. Um, and then, as I was saying, I do think there are, well, let me talk about the statutory interpretation. The association takes the position that there are two different and separately enforceable liens that in different avenues on which they may enforce those liens. The automatic statutory assessment under 33-1807 and the lien under the civil judgment. But their interpretation defies and puts these two statutes in conflict. I think, 33-1807 may not be a model of clarity. I do think it's unambiguous in what it says, but when you try to use ARS 12-1553 as the association, it puts those two statutes in conflict. And the maxim in interpretation is one we need to look to and try to enforce the legislative intent as best we can. And the best way to do that is by unambiguous language in the statute. But if there is truly conflict between two statutes, then we look to the more recent or the more specific. And here, 33-1807 is both the more recent and the more specific.
So, generally speaking, if a statute grants a right or a power to a party, that doesn't necessarily withdraw the other avenues that would otherwise be available to a party to enforce a right. But you're saying that because the may not be foreclosed language is so broad in scope that that's the end of the story as far as you're concerned.
Yeah, I mean, if there's two different rights, I agree with you that, they can both be pursued. But when there are limitations placed on other rights, I think that is determinative. It says, oh, okay, and generally you can get a writ of general execution and do your collection, including the sale of the property. But when there's another statute that specifically addresses this instance and places limitations on those rights, that you have to look to those limitations and apply those limitations.
Thank you, counsel.
And the last thing I just want to touch on is the case cited in the opening brief of Baker v. Gardner. I think that's right on point as to what's happening here, although it discusses different statutes. In that case, a claimant or a plaintiff tried to get around the monetary limitations of the anti-deficiency statute by suing on the note instead of foreclosing. This court, when it looked at it, said, well, you can't do that. That violates the intent of the anti-deficiency limitation. And that's the same thing that's happening here.
Counsel, I do have one practical question. It may not be in the record, and if it isn't in the record, that's fine. Your client declined to claim a homestead exemption. Is there a reason for that? I couldn't find the reason in the record on that.
Correct. He did not assert the homestead exemption. It is a rental property. It's not his primary residence.
Thank you.
With that, if there are no further questions.
Just very quickly on the motion to dismiss, do I understand correctly that your position is for the association, in any remaining steps, there are no legal impediments? The association's next steps are basically, lack of a better word, ministerial. They just execute, and that's why.
Correct, and that
right.
what the Superior Court did was final, and it, as cited in the case law Williams that I did in the responses to both those motions, what the court looks at is for certainty. If there's a promotion of certainty, the court likes to, or has indicated that it will accept jurisdiction under 1221-01.
Okay, thank you.
All right, thank you.
May it please the court. My name is Charles Workin. I represent the Appalachee Rancho Mirage Homeowners Association. And with me today is Ashley Mascarello, who is on the briefs.
Counsel, I apologize for hijacking your argument from the start, but it seems like the critical language is may not be foreclosed. And how do you read that? And I think you read it much more narrowly than your colleague does.
Well, I think it is important language, Your Honor, because the enforcement of a judgment isn't accomplished by foreclosure. The statute speaks of the foreclosure of a lien for unpaid assessments in the same manner as a mortgage. And the manner in which you foreclose a mortgage is to file a separate judicial action. And I would cite the court to 33-721, I believe it is. But to enforce a judgment for money is a different matter entirely. One may enforce a judgment for money in several ways. There could be a writ of garnishment, but here we're contemplating a writ of execution that would be issued to the sheriff without any further or separate action as in a mortgage foreclosure action. The sheriff would then go out and knock on the door and would first look for personal property, and if there was none, could then look to any real property that is owned by the judgment debtor. So it is not a foreclosure process. That word foreclose in this statute, 33-1807, does not contemplate and does not include enforcement of a simple money judgment by way of a writ of execution.
So you're not bothered by that language because you're not going to foreclose.
That's correct. And the next, well, part of that same sentence, Your Honor, the association's lien for monies other than for assessments may not be foreclosed. Well, we're not even acting on a judgment lien. We're acting only on the judgment, not on a judgment lien.
Okay.
So this statute, as Judge Weinsweig observed, may not be a model of clarity, but what it is clear about is that there are different things going on here in these statutes. And if you look at 13-1807 and then look at 12-1551, I believe it is, not 1553, although that comes into play, but 1551 is the statute that authorizes the enforcement of a judgment by a writ of execution. And so if we're comparing statutes...
Counsel, this
Yes.
statute, this lack of, the not a model of clarity statute, taken generally, seems to me, and please correct me where you think I've gotten this wrong, seems to me to set forth a process saying homeowners associations have recourse when an owner of the property fails to pay their assessments. They can get a lien, or they automatically have a lien for
Yes,
those assessments.
yes.
They also can get a lien and a subsequent judgment for related fees and charges. But the only way that the homeowners association, by virtue of this process of these assessments and fees and charges, the only way that the HOA can take someone's home to satisfy that debt is if there are still the associated assessment lien. In other words, here, under these facts, where there's no more assessment, there's no lien for the assessments, there's just the lien and then the subsequent judgment for these other fees and costs, you can't foreclose, meaning the purpose of this statute is to prevent exactly what's happening here, and to allow the HOA to proceed through a different mechanism would, in essence, thwart the legislature's purpose in promulgating this statute.
When the legislature adopted this statute in it was before 1997. It was in 97 that subsection A was amended to add the last sentence, which Judge Howe questioned its criticality. This statute, 1307, was adopted after the writ of execution statute, which we've had for decades. It was amended in 97 to add that last sentence. But since then, the legislature has amended 12-1551D multiple times. And in none of those occasions have they, in that list of exclusions in 1551D, have they sought to add as an exception, meaning that the writ of execution statute does not apply to these listed circumstances. They have not listed as an exception a situation such as this. So it is still possible, and 131807 contemplates the ability of a homeowners association to get a money judgment for monies unpaid other than assessments, and then the homeowners association can invoke 1551, which is unlimited.
So they can get the judgment and then just skip over that last sentence of this statute because there's another statute that allows them to bypass.
Well, I wouldn't
that.
I wouldn't say skip over. I would say the last sentence doesn't apply because the homeowners association is not acting to enforce a judgment lien, and it is not trying to enforce the judgment through foreclosure. One just doesn't enforce judgments through foreclosure. Those things don't go together.
The basis, I'm asking, the basis of the judgment, the civil judgment that you got here.
Yes.
Was based on a lien for...
No, it's not based on a lien at all. It's based on the obligation under the CC&Rs to pay certain amounts and to pay penalties when they're imposed, to pay late charges, other than late charges on assessments. So this judgment does not find its genesis, its origin in a lien.
So to the extent, and I'm speaking broadly, to the extent that there's a lien on the property, it came after the civil judgment. So you're trying to execute the judgment. Right?
Yes, and Your Honor, we don't even know in this record, I may be mistaken, but my recollection of this record is that we don't have any evidence that the judgment was recorded to make it a lien.
Okay.
But even if it was, it doesn't matter, because when the sheriff goes out with a writ to collect on a civil money judgment, it doesn't matter whether it's been recorded as a lien. He first is looking for personal property, and then he's going to look to any other real property. This isn't a judgment that would give rise to a writ of special execution, which is a judgment that specifies that certain property is the subject of this judgment and may be executed on to satisfy this judgment. That is not the situation that we have here. That is a different animal also.
If the purpose, and again, I'm asking, I'm not stating a position. If the purpose of 1807 is to prevent homeowners from losing their homes to foreclosure by failing to pay the assessments and the related costs, what good does this statute do if the HOA can just choose a different procedure to achieve the same outcome?
Well, the legislature has given us these statutes, and we have to make sense of them as best we can. And
I think Judge Howe's point is we shouldn't, it's a little bit troubling to look at 12-1551 as nullifying 33-1807 if the legislature has given us both.
Well, I don't think it is nullifying the writ of execution statute. And let's step back from...
I'm talking about the reverse. The
Yeah.
writ of execution, treating the writ of execution statute as nullifying the HOA statute.
And I misspoke. I heard what you said, but
Okay.
I turned it around. I'm sorry. Let's keep in mind what we we just heard here. But let's keep something else in mind first, and that is that the homeowner who's facing a sheriff knocking on the door with a writ of general execution based on a civil money judgment can still go out and file a homestead declaration, or record, I should say, a homestead declaration. And that is how, and that's another statute that, we ought to consider in this whole mix here.
But he couldn't hear because he didn't own the house.
Now you bring me to, no, he owns the house,
Oh,
but it's not his homestead.
okay.
It's a rental property. So why would the legislature
understand.
want to protect an investor or a landlord who has a rental property in the association,
Okay.
who doesn't pay his bills and then suffers or causes to be issued a money judgment? And why should the HOA be deferred in trying to collect that any way that it can under this panoply of statutes that we have?
So, counsel, you used the word genesis.
Yes.
And I think the point was that the judgment, the genesis of the judgment is CC&R.
It's,
So my question to you is, could your client have just filed a breach of contract action?
they did,
No, just
yes.
based on whatever non-payment of assessment, excluding one count, breach of contract, that's permissible. for
Yes.
the HOA to do.
Yes,
And the only utility of this statute is the automatic lien. What does this statute bring? Why does this exist? What is the utility of this statute? Is it automatic
long
lien?
before-
Why would you pursue this?
I don't mean to interrupt you.
No, please, go ahead.
Okay. Long before this statute was enacted, we had subdivisions subject to CC&Rs that commonly, typically said that if you don't pay this, that, or the other thing, it will be a lien on your property. And over time, the legislature has sought to regulate HOAs. And in doing so, one of the steps they took was to say, okay, whether your CC&Rs say it or not, if you don't pay your assessments, it's an automatic lien, and the HOA doesn't have to go through a judicial process in order to perfect that lien, if you will.
So this is a term filler, meaning you don't have the HOA, we just want to make sure, you
Yep.
don't have the CC&R, but guess what? We're going to have a term filler in the statute that says you still get your automatic.
Well, but there's more to it, because then the HOA also said that in order to, again, regulate this, that the assessments have to be delinquent in a certain minimum amount for a certain minimum period of time.
And
So there's a bit of give and take here for the benefit and protection of both association and homeowner.
But when you said that your client could have pursued a breach of contract
They-
action, they wouldn't have to worry about the
What-
year or, what are the other limitations? The year or there's an amount limitation?
Yes, about $1,200, I think. But
Right.
those are with reference to unpaid assessments. Now, if you fail to maintain your home, for example, in the HOA, which has some landscaping regulations under the CC&Rs, let's say your place is an eyesore.
Right,
And
no,
so-
let's talk about assessments.
Yeah, but-
Unpaid assessments, could you file just a breach of contract action to pursue that as an HOA?
If there are only assessments unpaid, could we file? Yes, we could file a breach of contract claim for those unpaid assessments. But
Don't
then,
worry about these
but-
statutory limitations?
but then that, I am not arguing that we can get around this statute if the subject of the debt is unpaid assessments, that we can take that to a money judgment and then go out and get a writ of execution and come back and take the home,
Well, this
because,
case is about unpaid assessments.
sorry?
The case is about.
No, it is not.
And then fees and penalties that are their tail.
No, at the beginning, there were a host of unpaid amounts or categories of debt. There was assessments, there was late charges on assessments, there were violation fines, and there were collection costs and fees, which haven't been allocated or segregated between those incurred relative to the assessments and those incurred relative to the non-assessments. So, but by the time it got to judgment, the defendant had paid the assessments, taking that out of the equation, and therefore, count 2, I believe it was, for foreclosure of the automatic lien was dismissed. We end up with a money judgment for these other non-assessment amounts.
And is something cleansed of its assessment character if the assessment is paid? I mean, if you have a fee, a hook for non-payment of assessment, like 12-340-101 on a contract, is it cleansed of its assessment character if you pay that assessment?
But we're not talking about fees for not paying the assessments. We're talking about other violation fees unrelated to the non-payment of assessments. As I was trying to make the example of the home being an eyesore, and you get the notice that says, clean up your place, paint it, rehang the shutters or whatever it is within 30 days, or you get this monetary penalty, which the statutes also permit.
I thought just a moment ago when you were listing the categories of non-assessment fees, you specifically listed late fees for failure to pay the assessments, and you also listed collection fees and costs, which would have been related to all of the above, right? Or all of the previously stated? Or were you just reading from the statute?
I was looking at, no. The statute, of course, contemplates broadly, two different categories of indebtedness. Assessments, late charges, charges for late payment of those assessments, and collection fees and attorney's fees and costs with respect to those assessments. That's one category. Then separate from that, you can have other fees, charges, late charges, because you can fail to pay a penalty, and that could accrue interest or a late charge, depending on what the documents say.
Well, what did we have here?
What we have here, and I was going to go to the complaint, but I was looking at the affidavit in support of the motion for summary judgment, and at that time, the amount, and this is the amount that gets translated into the judgment, is for outstanding assessment late charges of $60, violation fines of $790.
But that's not explained. What violation?
I'm sorry, Your Honor, I don't have that detail.
But it has nothing to do with the assessment.
It's not, right, correct. And then there were collection costs and fees that were related to both the delinquent assessments and to the violations without being segregated. I mean, if I could go back and rewrite this, I didn't write it then, but if I could rewrite it now, I would be more careful and separate it, because then the defendant probably would have paid more of this amount, or we would have a judgment that, might be foreclosed in the manner of a mortgage, and count 2 wouldn't have been dismissed. I'm sorry. And before I run out of time, you brought up the motion to dismiss, and I don't think we ought to be having this argument about the merits and the statute, because this issue is not ripe. There has been no writ of execution issued, let alone levied on real property.
What is left to do to get the writ of execution?
You go to the clerk. You go to the clerk with a precipice, if they want those anymore, and you push a writ of execution across the counter. They stamp it to issue it, and then you give it to the sheriff. But at that point, when the sheriff goes out, maybe he's going to satisfy the judgment from personal property, maybe not. Maybe he's going to be directed to other real property other than this house. Or maybe the debtor is going to then record a homestead exemption on this very house because he's decided to move into it or claim it as his homestead. all sorts of circumstances could occur, and at some point in that process, if he's unhappy with what's going on, he can seek relief from the Superior Court, and if he doesn't get it, he can come back to this court.
Counselor, I've been holding on to this question. Something that you said earlier is I'm confused. I interpret your argument to mean that whatever rights 1807 gives the HOA doesn't matter because we're going under the general civil judgment statute. And I thought that was what your argument was, but you disclaimed to Judge Weisberg that you were trying to get out from this statute.
I don't need to get out from under this statute because it does not apply. Because we are not foreclosing on a judgment. One does not foreclose on judgments.
Okay.
We are enforcing a judgment through writ of if ever, and as I just said, we're not doing it, but if it were to ever happen, that would be the manner of enforcement. So this statute that speaks of foreclosure and speaks of a judgment lien does not speak to this case. It does not speak to this judgment. And therefore, we can do what 1551 allows, and that 1551D does not disallow.
Thank you, Counsel.
Thank you very much.
Counsel? And Counsel, if I might ask you to address first, the argument has been made that 1807A just deals with liens and foreclosures, and that's not what's happening here.
I would address that again, it's similar to that Baker case. You know, they tried to get around the anti-deficiency statutes by not foreclosing and instead suing on the promissory note. And this court said, well, that defies the purpose of those statutes. And I would argue the same thing here.
But the title of this statute, 43-1807, is lien for assessment. And your colleague just said that this judgment has nothing to do with an assessment. It has to do with a violation for ISOs. Are we saying that any possible indebtedness or payment that homeowner owes to homeowner association in the course of that relationship, whether assessment or not, or assessment related or not, falls under this statute?
I do believe that's what the legislature said in those last two sentences. You know, the association's lien for monies other than for assessments and those related assessments and those charges related to assessment may not be foreclosed upon. And it does recognize that you get a civil judgment for those violation fines and the things.
But the statute says the association is lien for monies. The argument has been made there is no lien for monies. There is only a civil judgment. So if there is not a lien for monies, how does 1807 apply?
I think, you know, again, I'm going back to that Baker case. You look for the intent and for them to say, well, we can't foreclose on your house because the statute prohibited, but we're going to get a forced sale of it anyway under a general execution.
Well, not anyway. I mean, it sounds like it's a completely different claim, different DNA, right? Assessment, the statute. I was thinking, what if a homeowner slugged the secretary of the board in the jaw and he brought some sort of assault or tort claim? I mean, at what point does it fall outside the character so different that we don't pursue under the statute? So here, apparently, violation for whatever term, that's close enough, is what you're saying, to an assessment, that it should be precluded under Baker, because it's circumventing the purpose of the statute?
Well, not that it's close enough to an assessment, but the statute, talks about the monetary penalties, the charges for late payment. And again, it says you can get a civil judgment for those things.
Which sentence are you?
The second to the last one.
Okay, so it starts off, the association has a lien?
Yes.
The association has a lien other than for, and we're not supposed to read the heading, I guess. The name of the statute, which is lien for assessments, priority, or maybe is it called under priority? The name of the statute is as follows: lien for assessments, priority, and mechanics and material men's liens. Where does your claim fall under that heading?
Well, I mean, I would say it doesn't necessarily fall under that heading, but we should look to the actual language of the statute rather than its heading.
Well, it seems you kind of kind of have it both ways. You want to look at the language when it's helpful, but then we're supposed to consider the intent when it doesn't. Because the statute clearly says you may not foreclose. Foreclosure has a particular legal meaning. So if you're not engaged in the process of foreclosure, or if you're not trying to do that, has 1807A prohibit anything?
And it's going to this title of the statute. It talks about liens for assessments, and to answer your question, we do need to read what the statute says, and it talks about fees, charges, late charges, monetary penalties, or interest. And
May not be foreclosed.
right.
That doesn't mean may not be executed upon, which seems to be how you're asking it to be read.
Well, I would say not broadly may not be executed upon, because I would agree that they can do wage garnishments and your standard collection processes, but this statute says you can only sell the property to collect down that judgment in certain situations.
If a bank has lent money to someone to purchase a house, and they have that secured, and perhaps I'm misunderstanding the law, but they can either go after the promissory note for failure to pay in case of a default, or they can foreclose or execute on the deed of trust. So one doesn't preclude the other. Is what choice is made at the beginning, and it wouldn't that work here because the HOA isn't going to the lien route; it's going to the civil judgment route.
Yeah, and again, I'm going back to the Baker case. Look at the intent, the legislative intent.
Thank you, Councilor.
I see my time.
We appreciate your argument today. We take this matter under advisement and issue a decision in due course. We stand adjourned. Thank you.
First, thank you for the argument.
All right,
It was
very
a
good.
boxing match.